that happens predominantly in family law and in criminal law, in those topics that I teach. And a lot of it, I think, is just inviting students to think differently about the way in which those areas of law might impact all sorts of people. There are so many myths about what happens in relation to family law and what happens in relation to criminal law about various groups in society, not just Indigenous Australians. So inviting them to think about a broader context is something that we do quite specifically in relation to Indigenous people, be that as victims of crime, as perpetrators of crime, different constructs of family and different family responsibilities and how that may get dealt with within the family law system, those kinds of issues. But all of that really is just about inviting students to think about perspectives that they haven't necessarily experienced themselves or considered themselves.
In education, I do it through a discussion on the differences between equality and equity as overarching concepts. And over time, I've refined that to the point where, after seeking definitions of what that might be, I then observe that, were I to adopt a policy of equality, there would be an assignment set and there would be a due date. And because everybody had equal opportunity and access to the same resources, there would be no extensions. Were I to believe in equity, I would recognise that some people face particular circumstances that mean that those criteria shouldn't apply as equally. So we then have a discussion about whether the classroom should run on the basis of equality or equity. And by that stage, many students are very interested in equity.